Hey, everybody. How are you tonight? As you can see, I'm not in my usual place. I am still in La Cañada, California, with my family, and I'm going home tomorrow. So, uh, we're going to do a quick hour-long visit tonight to talk a little bit about P. Diddy and about Adelson because there's a lot of big news on both of those things. Um, I did want to say hi to Julie Reichardt, who I see in the chats, who I got to know when I was living in Boise, and I miss and say hi to Jane, who I'm sure, if she's not listening now, will be catching the repeat. So, my friends and Cheryl, my friends from Boise. So, cause I miss you guys. So, next week, just a few short days away, on the 24th, um, we're going to have a book. And on the 26th, I am going to post this all. I'm going to put a post in the show notes, as well as a community post on YouTube, with all these dates. But the 26th of September, I am going to be in Portland, Oregon at Powell's Books, which is a huge honor for anybody who is around Portland and knows Powell's Books. They are the largest independent bookseller on this side of the Mississippi, as far as I know. And they have the most amazing bookstore in downtown Portland that takes up one whole city block and 3 stories, and you can get lost in there. I used to have a friend who used to say, when he went shopping in there, he'd have to pop smoke and put up a smoke bomb so that everybody would know where he was. Anyway, I'm going to be there. I am going to be in Portland on September 25th, and I am going to do not one, but 2 interviews on KATU Channel 2, which is one of the large local stations in Portland, talking about the book, both on their morning show and on their afternoon show that airs just before the local news. So that's exciting. And then on the 26th, I'll be at Powell's that evening in this Cedar Hills, Cedar Mill location, which is their satellite store out on the west side of Portland. And then on October 10th, I am at Roundabout Books in Bend, Oregon, which is going to be really fun. And we're also working really hard on an early November date for both Boise and McCall. Right now, I know I'm going to be in McCall, Idaho on the 3rd of November. And we're hoping to do something in Boise on either side of that date. So super excited for that. I have a couple of other dates, other places in Oregon. One in Ashland, Oregon, beautiful Ashland, where the Shakespearean Festival happens every year. And also in Sisters, Oregon. So I'll get those dates out, and dates are still coming in. So we'll see. A lot of things to think about after the first of the year. So, but we have a ton to talk about. And I thought tonight I would just because we're going to keep it short tonight, I thought we would just chat a little bit about the arrest of Sean Combs, P. Diddy, as well as talk about the big developments in the Adelson case. So let's start out with P. Diddy. Now, I have to tell you that if any of my streams are going to get demonetized, not that that's very important to me, but it might be this one, because the story of what was going on with P. Diddy is absolutely awful. And so trigger warning for anybody who is sensitive to sexual violence. because P. Diddy is in a lot of deep trouble for some very serious allegations of sexual violence and human trafficking. So, if that is a sensitive subject for you, tonight is not your night. I do also, before I get to P. Diddy, I do want to tell everybody that I did hear from the folks who have purchased the DeBell property, and they're scheduled for demolition tomorrow to knock down all the buildings, including the house, the barn, the chicken coop, all of that. And they're really trying to move that ahead before winter, so that that cleanup can be done and they can start looking at designs and plans for a project in the spring. So it's exciting. I also want you all to know that they have been working closely and have been in contact with Kay and Larry, with Summer, with Colby, and with many of the other members of the family. So I just want to assure you that any bumps in the road that may have happened, I think, have been ironed out. I'm not involved. I just happened to get a text from them telling me that that's where they were going. They have been working closely with Nate Eaton, who has been covering the story for East Idaho News. So that's all good news. So let's talk about P. Diddy. So we know that several months ago, there were lots of folks who, there were a lot of, I was just going to double check the chat for sound, please, because I am working off of my laptop and off of my laptop's microphone. So please let me know that y'all can hear me. It sounds like you can, because I'm seeing comments in the chat that might indicate that you're answering things I'm saying. So okay, thank you very much, Jacqueline and Teresa, for letting me know. So several months ago, the federal, the FBI and federal law enforcement served warrants on several of P. Diddy's homes and residences. At one point, they handcuffed his sons and put him in the back of a car while they served the warrants. They were then released. There were never any charges filed, but they were kind of held out of the way while they were serving those search warrants. And a lot of people have had a lot of questions about what's going to happen with P. Diddy, because it seemed like this was a very intensive sweep and pretty comprehensive sweep of his properties. You all probably also know that his longtime girlfriend, her name, I think I've got this right, Cassie Ventura is her name. She met him when she was 19 and he was in his 30s. And she filed there was a very famous bit of, thank you, Yvonne, since I'm, for a nice compliment tonight that I look nice. I am in my good friend's dining room, and I don't have all of my lighting and microphones and all that. I'm working off my laptop, so I appreciate that. So one of the lawsuits, a civil lawsuit, was filed on behalf of Cassie Ventura, alleging that P. Diddy had been abusive to her, controlling to her. There was a very famous bit of video that surfaced from a hotel where they were at that was very violent and abusive, where he was abusing and mistreating her in the hallway. And following that surfacing, then she filed a civil suit against him. So it was very it was very, oh, good. Yeah, I did hear that Nate Eaton, I'm sorry, I'm trying to read a couple of the comments. There we go. Uh, that I did hear that Nate was going to have somebody out there tomorrow, not live streaming. We do not want this property to ever be presented like circus atmosphere. I should say we. I don't have anything to do with it, other than the fact that the folks expressed to me that they did not want that to become sensationalized or any of that. They wanted to be as respectful as possible. So my understanding is that the folks from uh, uh, East Idaho News, and that looks like Frady's, will be out there to do a story and document the demolition. So um, and I think that many people feel like this is sort of the closing of that chapter, and that they can move on to do something hopeful and positive with the property, rather than it being sort of a, a magnet for looky-loos. I think I mean, I understand there are still daily, at least, people driving by and looking at the property and those sorts of things. And I understand people are curious, but I think it will. I think it will be very helpful to move the dial forward. So, um, and thank you for Frady's being out there to report on it, and thank you, Nate. So to get back to P. Diddy, so. A lot of people were very curious about whether or not there were going to be charges brought against P. Diddy after all of these search warrants were served. And as it turns out, they had collected so much evidence that it has taken them a long time just to process the evidence and understand what it is they had. They had uh, many electronic devices, cell phones, um, hard drive storage units, and a lot of other things. So, for those of you who might be a little squeamish, plug your ears, because it appears that Diddy was um, sponsoring or organizing these what he called freak offs, and they were literally drug, alcohol, and sex fueled frenzies. And he often forced Cassie into sex with other people while he filmed. That wasn't, I mean, it wasn't just her, it was other people as well. And definitely using his power and his influence to force people to do things that they would not have otherwise done. Um, Very violent, very, very coercive, using his power to um, force people to do things, because if they didn't, he would ruin them. They would never work again. They wouldn't get music contracts. They wouldn't, really misusing his power. Very a la Jeffrey Epstein, frankly. So, and so they have now charged him with a number of federal crimes. Now, remember, federal court does not allow cameras in the courtroom. So we are sort of limited to being able, relying on people who are actually in the courtroom to report. Which, then you have to rely on folks like the folks on Court TV and Law and Crime and all of those folks who have the resources to have somebody in the courtroom. So what we are being told is that following his indictment yesterday, he was arraigned on the indictment, and the judge refused him bond. So today, his lawyers asked a different judge to reconsider his bond. And after this judge, the judge today, heard the information, that judge also denied bond. And, you know, we have to remember that there is a constitutional right to bond, but there are also circumstances where a judge can say, and again, it varies between federal and state, have slightly different um, criteria for bail. But in general, people have a constitutional right to bail unless unless they meet certain criteria. And a lot of that criteria has to do with whether or not that person poses a flight risk or that person is a danger to themselves or others. So you might recall that when Vallow Daybell happened, initially, when Lori was brought back from Hawaii, her bail was set at $5 million. And that's a lot. I mean, that's a lot even in a murder case, even in in a sort of slam dunk murder case. So when she came back to Rexburg, then the judge reviewed that and reduced her bail to $1 million. Now that was still a lot, considering that the charges that she was brought back on were very low level felonies. They were in fact there were 2 misdemeanors and only 1 felony. And the misdemeanors were deserting her children, and the felony was trying to get Melanie Gibb to lie for her, so that saying that JJ was with her. So once then the children's bodies were found, they piled on the destroying evidence charges. But if you'll recall, they didn't actually bring the indictment for the murder charges until 2021. And all of that had a lot to do with COVID and the fact that they had suspended doing, sorry for all the uhs tonight, doing grand juries. So they had suspended doing grand juries because of COVID. And it wasn't until COVID was waning and they reinstituted grand juries. Now, you might remember that there was a preliminary hearing for Chad, and that was on the destroying evidence and those charges after the children's bodies were found in June of 2020. But it wasn't until later that the murder charges were filed. And yet the judge upheld $1 million bail. And there were some reasons for that. The reasons had to do with the fact that Lori was in contact with quite a few of the people who were potential witnesses, and the fact that she'd already fled to Hawaii. So similarly, in the Diddy case, there was ample evidence that ever since the first search warrants were done, that he had been pretty systematically letting people know, don't cross me, don't rat me out, because it's not going to go well for you. So there was ample evidence that he was doing his best to influence anybody who might be a witness. So that was first. And the other, of course, is that he's a substantial flight risk. I mean, he has nearly unlimited resources. So pretty clear that it was likely that he could flee. He's got access to private aircraft and could go anywhere. Now, his lawyer made the point that he didn't flee after the search warrants were served months ago. He didn't flee. So his lawyer made that point, but the judge wasn't persuaded. So judges can take additional information into account. In Lori's case, they were taking into account the fact that her children were missing, even though the children had not been located yet, and we didn't know whether the children were alive or not. And took into consideration the fact that Lori had already fled to Hawaii. In Diddy's case, I think they took into consideration a lot of the allegations that were made in Cassie. There's several other civil cases beyond Cassie's, but I think Cassie Ventura's is, I read the civil case and it is chilling. Her pleadings go on for about 16 pages, I think, of just recounting all of the awful things that he did to her and some of the really horrible abuse. So judges are able to take those things into consideration, even though they are not, perhaps haven't been charged in his particular case. So the judge decided that there was no amount of bail that would secure his return and keep him from trying to influence other people. So he's in jail. The indictments and Cassie Ventura's civil case are readily available all over the internet. There are lots of folks who've been posting them, especially on X, Twitter. So they're out there if you want to read them. I am not going to post them because they're hard to watch and hard to read. So moving forward, they're out there for anybody who really wants to find them. I do want to mention just a couple of like little passing things before we get on to Adelson about Sarah Boone's case. So there have been some motions filed back and forth about Sarah Boone's case having to do with getting experts who can testify about the battered spouse syndrome that she's alleging. So it's a little bit weird because on one hand, she is saying, oh, it was a terrible accident. Jorge and I were playing around and we'd had a lot to drink and I didn't realize he couldn't get out of the suitcase and I kind of went to sleep / passed out. Or I zipped him in there because I was afraid when I let him out that he would abuse me because he's been abusive in the past. But here's the dilemma that they have. And that's that they're really going on two diametrically opposed theories. So on one hand, they're saying, oh my goodness, it was a terrible accident. I didn't realize he was still in the suitcase. And on the other hand, they're saying the exact opposite. I knew he was in the suitcase, but I was too fearful of what he would do when I let him out to let him out. So it's hard because the prosecution is saying, pick one. It can't be either. Exactly, Jennifer. Pick a lane. And right now, that is difficult. So her counsel is really going to have to pick a lane. They're going to have to focus in on what their theory of the case is at this point. Because all of her initial statements to law enforcement were, it was a terrible accident. And it wasn't until much later that they started talking about the fact that potentially it was because she was afraid of what he would do if she let him out of the suitcase. And then, of course, there's that pesky video of her taunting him while he is in the suitcase and knowing that he's saying, I can't breathe. So there's an interesting post there from Frades, who is a reporter with East Idaho News, I do believe. And so the comment is, P. Diddy's lawyer mentioned that he moved to New York in anticipation of the charges. How that positively affects his position in front of the court, maybe help with the possible bail. Well, I think that's a possibility, but remember, these are federal charges. I think at the time he didn't know whether the charges were going to be brought in New York or federally. So the federal charges, it probably isn't going to have as much impact on the potential charges, but I could see where he could be doing what we call forum shopping, which is looking around and saying, if I were to get arrested in New York, what would that look like? Versus if I were to get arrested in Florida, what would that look like? So we know what happened with Jeffrey Epstein. We know that there were, that Florida kind of came down pretty hard on him, at least initially. And it potentially, maybe, and it could be something as simple as Diddy felt like he had more sway over influential people in New York than he did in Florida, too. So, little hard to say, but the fact that they're federal charges and that it was a federal magistrate who made the decision, or a federal district judge that made the decision on his bail, I think may not have had much impact on which location he was, but he may very well have been forum shopping, not knowing whether they were going to file the state charges. And remember, they could still file state charges. As we saw in Murdoch, we saw state and federal charges filed, and there are a number of charges that they could bring against him in New York. So it may be that he thought he would do better in New York than in Florida. Now, that doesn't mean that they can't charge him in Florida. They certainly could charge him in Florida for crimes that happened in Florida. So one of the things that they've talked about is the fact that he firebombed Kid Cudi's car when Cassie Ventura was talking to Kid Cudi, and she kind of thought maybe that P. Diddy would see that as a positive because she was talking to him about furthering her career, and instead he went into a jealous rage and dropped a Molotov cocktail in Kid Cudi's car. So that all, and I think that happened in Florida. So those charges could come in Florida, even though he's moved or moved his residence. It's harder for people who have residences in many places because it's a little bit harder for him to say, oh, my residence, my domicile's in New York. Well, 2 weeks ago, it was in Florida, where you also own properties. So it's a little bit harder to blur those lines when you're somebody who has property in many different places. So anyway, it's going to be really interesting at the risk of overusing that to see what happens next. Because I think a lot like Jeffrey Epstein, there are a lot of people who are going to be very emboldened by the fact that Diddy is in jail, very likely in segregations for his own safety. So I think it is going to embolden a few people who are going to think, okay, I'm safe to be able to tell my story. I thought it was really interesting. Now, I'm probably going to get this wrong, but there was a guy who was arrested for taking a gun in and opening fire in got an attempted mass shooting, and he said, the abuse that I suffered at the hands of Diddy and his friends is what tipped me over the edge into a psychosis where I did that. So you all probably have seen that and can identify that better than me. But I thought that was really interesting. So I think we're just seeing the pebble dropped into the water, and we're going to see the impact of that happen going out for a long time. So let's talk about Adelson. Oh my goodness. We were literally on the morning, literally, I'm not overusing the word literally. We were on the morning of jury selection beginning when Daniel Rashbaum admitted to the court that he did not have a full waiver to represent Donna Adelson. So let's talk a little bit about conflict of interest and waiver. So let me take a drink here of my lime seltzer. Let's talk a little bit about waiver to begin with, and well, conflict first. So it is a conflict of interest for a lawyer to represent two people whose interests could be opposing one another. So if we think about it this way, Dan Roshbaum represented Charlie. Now, if you go far enough back, Dan Roshbaum initially was retained by Donna and Harvey at the time that Sigfredo and Luis and Catherine Magbanua were being accused of crimes, and it was sort of tipping over to Charlie. Law enforcement had done the bump. Law enforcement was getting all of the Adelson dental practice records to prove that that Donna had been paying Catherine. A lot of those things were happening. And they initially retained Dan Roshbaum. After that, when Charlie was charged, they then asked Roshbaum to represent Charlie. And initially it was Charlie who had to say, yes, I would waive any conflict with my mom and dad, and you're representing me. So both sides. So here's the thing that that makes what happened this week, explains what happened this week. When you have a conflict where a lawyer is potentially going to represent clients who have opposite interests, you have to obtain a waiver from both clients. So initially, when Donna was arrested on the jetway and brought back into court, the judge questioned her quite extensively about her understanding of the conflict, because by that time, Charlie had been convicted and Daniel Roshbaum had represented Charlie throughout that entire trial. So the judge inquired of Donna, do you understand that there is a conflict, that there's a potential that your interest and your son's could be opposing one another? And so do you understand that it's possible that Daniel Roshbaum could have access to information from you that also, or from Charlie, that he wouldn't be able to share with you, and vice versa? And Donna said, yes, I understand that, and I still want Dan Roshbaum to be my lawyer. So and at that point, that was a sufficient waiver for the judge. It was done in open court, on the record, everything was documented, and that made perfect sense. So up until the state and the defense both put Charlie on their witness list, that waiver was sufficient. Now, the next thing that happened was the defense. Now, the state has said that they didn't necessarily think that they would be calling Charlie unless it were as a rebuttal witness. But he was on their witness list and they issued a subpoena for him. Well, the defense also issued a subpoena for Charlie. Charlie was in North Dakota, if you remember, not too long after his conviction. The Florida State Prison said, we're not really sure we can keep Charlie safe because of all of the notoriety of this case and the fact that he kind of threw the Latin gangs under the bus. And there are a lot of Latin gangs in the Latin Kings. There are a lot of Latin Kings in the Florida Department of Corrections system. So they moved him to North Dakota. So he's been in a different state. One of the difficulties with that is that the folks who are getting ready for Donna's trial don't necessarily have direct access to Charlie. So while they are trying to get ready for trial, they send the subpoenas to North Dakota to him, and he is then brought back to Tallahassee for the trial. So Daniel Roshbaum at this point has had verbal conversations on the phone with Charlie since his conviction about whether or not he waives the conflict with Dan representing Donna. Verbal only. He has not gotten a signed waiver, probably because it was logistically difficult because Charlie was in another state. So to have somebody personally take a written form to Charlie, get it signed, likely notarized, all of those things would be kind of onerous. So I think that Dan just thought, well, I've already got Charlie's verbal agreement. And when he gets back to Tallahassee, I'll take the written form down there and have him sign it. So I think what happened was, well, I know what happened because Roshbaum said in open court that when he went down there with the signed form, by that time, Charlie had been consulting with his appellate attorney, and his appellate attorney said, no, I don't think that's a really good idea. Now, one thing to know about waivers, particularly waivers of conflict of interest, is you can withdraw your waiver because, and I see Tiff's question, and under certain circumstances, you can withdraw your waiver because circumstances change. And Rashbaum said that during his presentation or his conversation with the judge on the issue yesterday, I think it was, because he said, he could have withdrawn that waiver at any point if the circumstances change, and that's just what he did. So because when he gave the waiver back in December, the verbal waiver on the phone, he had not yet had the advice of this appellate lawyer who was saying to him, oh, no, you don't want to allow somebody to come in during this trial and cross-examine you, who also has access to inside information from your mother, for fear that that might taint your appeal. And the other issue is we don't know at this point, and the judge doesn't know at this point what the theory of the case is going to be for Donna. So we know that Charlie's theory of the case was this double extortion, right? So it was these guys who supposedly, according to Charlie, on their own with involvement from Catherine Magbanua, decided to go down there and kill Dan Markell, and then come back and say, if you don't pay us money, we're going to say you did it. That was their theory of the case for Charlie. It was very clear that the jury didn't buy that. We don't know at this point whether Donna is going to double down on that theory, or whether there is a different theory of the case for her. Whether she is simply going to say, I was silly and naive, I did not know that this is what was going on. I didn't understand when Charlie was trying to talk to me in code. I don't know anything about this. I was just the ignorant, naive dupe. Sound like Chad Daybell? Yes, it does. And I think it's going to be every bit as effective for Donna as it was for Chad Daybell, if you get my drift. I don't think anybody's going to buy that Donna was simply a an innocent bystander that got looped into this, and that she didn't really know what Charlie was talking about when he was speaking to her in code. So I don't see that. I don't know how they are going to move forward, what their theory of the case is going to be for Donna. I know that they have been desperately trying to keep out the evidence that she was leaving to go to Vietnam, because it shows consciousness of guilt. And I believe that the judge is going to let that in. And I do believe that that the jury is going to be given the jury instruction: if you find that this person was fleeing the country to a place with no extradition, you can assume that that is consciousness of guilt. So I think they're going to get that instruction, and I think that is going to be very damaging for Donna. So ultimately, what happened was, the prosecution and the defense both went to the court and admitted that we have this problem. And the problem is that we thought we had a defensible, clear-cut waiver from Charlie that it was okay for me to represent Donna. And now we're finding out that that's not the case. So now we're having to drop back and try and figure out whether we can save the trial date by having an uninvolved third party come in and do the cross-examination of Charlie, whether that would purge the contact or the conflict, or as they say, purge the taint, the tainted nature of the testimony. So the judge found that that Rashbaum had a clear-cut and non-waivable conflict at that point. Non-waivable because Charlie wasn't going to waiver, which wasn't going to waive, which meant that there's only one half. It's kind of like the teeter-totter. You've got to have weight on both halves. So without weight on Charlie's end, Donna was boop, up in the air. And the court said, you have a non-waivable conflict. So Rashbaum had to completely withdraw from the case. Then the judge took the other lawyer in camera in his chambers. So because the other thing that you have to know about conflict is there's this concept of a Chinese wall. I don't know where this term came from, but it is a term within the legal community that has been as long as I've been practicing. I think initially it was create the Great Wall of China. Okay, you want something that is as strong and as permanent as the Great Wall of China. What that means is, let's say that you have a law firm that has 20 lawyers in it. And lawyer A is going to represent, let's just say for general purposes, lawyer A is going to represent client Sally Joe, who slipped and fell and was seriously injured in Safeway. However, that same firm represents the insurance company that insures Safeway. Okay, so technically there's a conflict because you have two clients whose interests are directly and diametrically opposed. Sally Joe has a claim against Safeway. She has a vested interest in getting Safeway through their insurance company to pay up for the injuries she sustained. Safeway has a vested interest in getting their insurance company to defend against the claims so that they don't have to pay. And so what the judge is going to ask is whether those two lawyers within that large firm have ever exchanged information about those cases. Has the lawyer who represents Safeway's insurance company, do they know that somebody else in their firm is representing Sally Joe in an injury claim against Safeway. So in very large firms, it is very possible to build that Chinese wall. When a case comes in and the administrative people within the firm do the conflicts check and they say, so Sally Joe wants to sue Safeway. We represent Safeway. So I need to make sure that there are notes all over in both of these files that say, lawyer who represents Safeway's insurance company, you can have absolutely no conversations with lawyer who represents Sally Joe about these cases. And they literally flag the files. They say, no discussions with lawyer X about this case. No discussions with lawyer Y about this case. And so they keep that division so they can say, we have no conflict. Here's another example, and this is a real life example for me. I worked for a consortium of sole practitioners. So there were about 12 to 14 of us at any given time. We were public defenders. And I shared office space with 3 or 4 of them at different times during the years that I practiced. And so we were very careful that we didn't share administrative support. And if we did, that, for example, share a receptionist, that our receptionist knew that she was not to discuss our cases with anyone else and not to discuss the other lawyers' cases with me. And so, because we were also practitioners with our own discrete offices, we literally could have co-defendant cases where, let's say we had 3 lawyers in the building and a case came in and it was a big drug bust and there were like 15 different co-defendants. Well, then everybody gets a piece of that case. I mean, they're scrambling around looking for lawyers to cover all those co-defendants. They're making sure they've got them all covered. And in order to do that, that means that they very likely, I would have a co-defendant and my office mate might have a co-defendant. But because we had completely separate businesses, literally our offices are separate. My files are in my office under lock and key. Their files are in their office under lock and key, and never the twain shall meet. We could do that because that literally was that Chinese wall. But in the case where you have smaller firms, and let's remember that Tallahassee, even though it's the state capital, is not huge. So there were very few, let's just say maybe they're the same as Portland, Oregon. And there were very few firms of maybe larger than 10 lawyers in Portland, Oregon. And I would suspect there aren't very many firms in Tallahassee, Florida that have more than 10 lawyers. So it becomes a little more complicated when you don't have a really large firm and you don't have a kind of administrative staff that can be policing this all the time. So I don't know for certain what was done and what wasn't done, but I can tell you that the judge took this second chair lawyer, whose name is Alex, back into chambers and questioned him on whether or not there was a conflict. And that attorney was able to satisfactorily answer the questions to the point where the judge said, okay, you've been walled off and there is not a conflict. Because what the judge wanted to know was not how much information does this lawyer know about Donna Adelson. What the judge wanted to know was how much information that Dan Rashbaum was privy to in Charlie's trial has this other lawyer had access to. The judge was satisfied that the second chair attorney, at least to this point, has not had access to the information surrounding Charlie's trial. And it's perfectly appropriate for him to be able to review the transcripts of Charlie's trial, to be able to review all of the discovery, because that's things that he's entitled to. Where it gets sticky is if Rashbaum had confidential conversations with Charlie that could then be used against Donna. So that is where the conflict came in. So at this point, the judge has said, you can stay on the trial unless there's something else that becomes evident that you have had exposure to confidential information from Charlie, because Rashbaum represented Charlie. So I hope that makes sense. Please post questions either in our, in our chat if you would like, or in the comments below. I know some folks are not thrilled with posting publicly. If you're one of those folks, please drop me an email if you have other questions. Just a little bit of housekeeping before we start taking questions. You see that Jen's got some questions starred, so we're going to take them here shortly. But I did want to let everybody know we are still taking squares for the crane quilt for the Woodcocks, and I am hoping that now that I'm going to be home, and once I get the book launch week out of the way, I'm going to get my quilting set up. Fall is coming. And we're going to get that project finished for Kay and Larry. So if you have the instructions are in our show notes. There's a link to my Google Drive where you'll find the pattern. The squares finish to 6 1/4, which leaves a seam allowance for anybody who's a quilter. And please use a black background, any color for the crane. They look like an origami crane. The reason for that is because in Japan, people fold origami cranes in honor of someone who has died. And oftentimes the goal is to fold 1,000 origami cranes. We are not making 1,000 origami crane squares, but we are going to do something sort of lap quilt size. So we're still getting those. I have a new P.O. box. All that information where you can send them is in the notes. And I do still have a few Justice for Tylee and JJ wristbands for anybody who still wants one. I want to thank everybody who got the early version of the book. Some folks are already posting to Goodreads, which you can post to Goodreads. You cannot post to Amazon until the 24th. But the Amazon reviews are absolutely the most important for me. If I get 60 reviews on Amazon, that puts the book into the algorithm to be recommended for people who have previously ordered other true crime books. So please, 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 if at all possible, post a review. I will put in the show notes the links that you need to get to in order to post your review. Now, if you were part of the Book Launch League and you got an early copy of the book and you post your review, please email me with an address where I can send you a signed book plate as well as some swag. So please do that. We are coming up on the very, very end of the pre-launch window, because next week we are going to be in full launch mode. So please, please, if you have committed to post a review, please do it. And it helps me a lot if you do it the week the book launches, because that looks really good when it comes to standings within other, not necessarily Amazon, but within other publication lists. That's what I'm trying to say. So I just want to say thank you for everybody who has already posted. Anybody who has gotten back to me, if you email me a copy of your review and send me an address, I will send you goodies. I see a question here that says, when will the book be available on audio? It will be available the same day, on the 24th. You should be able to download it digitally if you are one of those folks who likes their Kindle or their e-reader, and you should be able to download it on Audible on the same day. I have not heard the Audible version yet, but we did pick my daughter and I had a little input on the narrator as we were in Nashville, and so I hope that you're going to enjoy it as much as I do, because I'm really excited about it. I know that we're kind of running a little late. We started late tonight, so I would be happy to answer questions. Who's got some questions about Adelson or P. Diddy or Carly? Lori, do you think the state will even offer her a plea? I feel like she may be ripe to take one, but with her age, the testimony they need from her, et cetera. You know, I really think that if she were going to take a plea, she would have done it by now. I think that a plea would very likely have required her to incriminate both Charlie and Wendy. And I'm not sure that she's at that place. I'm not saying that she wouldn't get there, but I'm not certain that at this point she would be willing to do that. So it's a good question. I would have thought that if she was going to roll over, she would have done it already. We wouldn't be doing jury instructions. There would be some sort of an announcement that they'd reached a plea deal, similar to Chad Dorman when he took a plea. So we haven't seen that, and I would be very surprised if we're this close to trial that they'd still be talking plea. In a lot of courts, the judge will say, here's the deadline, and if you haven't done, if you haven't reached a negotiated plea by this deadline, and I have to call in jurors, it's not going to happen. Now, realistically, you can enter a plea until and even after a jury is seated, but usually a judge is going to hold the feet to the fire of everybody and say, don't make me call in a jury if there's any chance there's going to be a plea. So, good question. Hi, Leah. Sorry, I'm having to lean a little close. My laptop screen isn't as easy to read as my desktop. Is it normal for the judge to make the defendant responsible for the costs, like Judge Everett said he was doing to Donna? Okay, this is a good question. So it is not as much about the costs, although in this case, Donna has retained counsel. So it's not a lot of the investigative expenses are not being charged to the state the way they would if she were represented by the PD or by court-appointed attorneys. So it's not as much about that cost as it is credited to the delay being credited to the defense. And here's why. Donna has not waived her speedy trial rights. And so they were charging ahead to get her trial in that speedy trial window. However, because it was her counsel that necessitated the continuance, that's going to be counted against her. And she is not later going to be able to say, I didn't get my speedy trial, because it was her and her lawyer's fault that the trial had to be delayed. So when they say it's charged against the defense, yes, there could be some costs charged against them, maybe costs of bringing in a jury and paying their mileage and maybe paying the first group lunch, who knows. But those are pretty nominal. What they really mean is we're going to charge this delay against the defense. And that means, Donna, you can't come back later and say, I didn't get my speedy trial, and I want my conviction overturned. So I think the stickier issue when it comes to speedy trial is going to be Lori Vallow in Arizona, because I don't think her side did anything to warrant a delay beyond her speedy trial rights, but the judge granted it because her counsel couldn't be ready. So, I mean, I guess you could argue that her counsel couldn't be ready and that should be charged against him. But it was the sheer volume of the discovery that the lawyer just said, I'm 8,000 pages in and I have another 100,000 to go. And I can't be ready. So, but this is a good question, because I think when we talk about, you know, the delay is going to be charged against them, you think, oh, money. But it's not entirely money. It could be some nominal stuff, but I don't think Donna's worried about that. So, good question. Hi, Mary. How was your move, Mary? I know that you were getting ready to move, so I hope that all went well, because I know what a headache it is to move. And I'm not doing it anymore, guys. I'm done. Oh, I do have exciting news. My daughter and son-in-law signed a lease on a house in Bend. So they're going to be moving in mid-October, which is the whole reason why we all were going to move back to Oregon, so we could all be living in the same communities, because I want to be that grandma if grandbabies are on the way. So, Mary, to your question, what happens to Rashi now? Does this have any legal implications for him or just stain his reputation? So I'm not sure it has serious legal implications for him. I was trying to move my camera to get rid of that little light that keeps sort of showing up over my ear. But I don't know that it has a tremendous implication for him. Ethics beef wise, I mean, it's perhaps the Florida bar might say we'd like to look into this, but I think he has a clear, he's made a clear record of why he thought it was okay and why it suddenly became not okay. So I think that's a pretty clear record. I'm not too worried about that. Certainly, it's not good for his reputation. And it may very well not be financially good for him, because Donna may demand some portion of his retainer back. It really is going to depend on what their fee agreement said, because, you know, it's very possible that his fee agreement says, you know, this is going to be a flat fee and I'm going to earn it for all the work I did, regardless of whether I have to at some point withdraw. Because I think they all understood that there clearly was a conflict. I don't think anybody didn't see that there was a conflict. It was just a matter of whether or not it was waivable. So a conflict kind of moving from waivable to not waivable is sort of a different kettle of fish. So good question. So yeah, I don't think it's great for his reputation, but I think that's probably about the worst of it. How's Chad's appeal going? You know, I haven't heard very much. I will look it up for next week. I know that they finally got the transcript, because they had to have the appellate attorneys had to have a complete written transcript of both his trial and Lori's. And they had to have time to go through that. So I think and it's a very labor intensive job. It usually takes 2 or 3 people, because one listens to the recording and transcribes, and then another one checks and double checks to make sure that that's exactly, everybody heard the same thing. And so it's a very labor intensive and expensive proposition. Once that is done, then they will have, then they will be told by the appellate court, you have so long to file your opening brief. But I would also say that I've written a few appeals and that were nowhere near as complicated as this one. And the appellate court will very likely slip that deadline again and again until they finally get their opening brief in. So it could be months before we actually see an opening brief. Then the other side will have time to respond, the state attorney general's office, and they're also dealing with a voluminous record. They're not really going to know the specifics of what the defense is alleging until they get the opening brief, and so they could get extensions on the reply brief, and it could be months before the court is. And then sometimes the court will allow a surrebuttal and a sur brief, and so there could be a couple of different rounds of briefs going back and forth before they ever even set it for oral argument. So I mean, I would be very surprised if we are looking at the court even hearing arguments, and maybe late 2025. I would suspect more like 2026 before we hear anything. And of course, by that time, Lori's Arizona trials will be over, and then she'll be back in Idaho to serve her sentence, but undoubtedly there'll be appeals in Arizona too. So good questions. Who is at fault for the waiver fiasco? I've heard people blaming the judge. You know, I don't really see it that way, because the judge was very clear with Donna Adelson the day that she was arraigned on her indictment. So she was picked up on the jetway. She was served with her indictment. She came to court for the arraignment on the indictment, which is when the judge says, here are the charges against you, and appoints a court-appointed lawyer if they request one. At that time, the judge said, Donna, do you understand that Daniel Rashbaum previously represented your son in a case that was virtually the same facts and evidence as your case? And do you understand that that presents a conflict, and are you willing to waive that conflict? And Donna repeatedly said, I want Dan Rashbaum and I'm willing to waive the conflict. So that was not the issue. The issue was that everyone, Rashbaum represented, and probably rightfully so, to the state and to everyone who asked, that Charlie had also waived. So he had both sides of the teeter-totter. And it really wasn't until Charlie got back to Tallahassee in the last week or so for Donna's trial that it became evident that he either didn't believe he had waived it to begin with, or he was withdrawing that waiver on the advice of his appellate counsel. Either way, that's not something the judge could have anticipated. So I don't really blame the judge. I have to say, I think this judge has been pretty darn even-handed from the very beginning. So I think the judge did everything he could to avoid it. It just was unavoidable. I mean, yeah, I guess you could blame Rashbaum for not having a written waiver back in December, but even had he had a written waiver, he would not have. He could have withdrawn it. This is a good point, Roz. In a January interview with Joel of STS, Joel Waldman, who is amazing on Surviving the Survivor, and he did actually, I think Dan Rashbaum, it's the only interview he's given. And he did say to Joel that he had waivers from all the relevant parties. So yes, it turns out that is true, not true. I'd have to go back and listen to what he said on Joel's program. It's not that I don't believe you, I do. But it is, you know, it it's possible he thought he had a written waiver because there was a written waiver. Charlie just didn't sign it. Um, or it may be that he thought he did, and he was kind of going on his memory of his conversations with Charlie. There was a written waiver, but Charlie didn't sign it. So, I want to caution everybody. These cases have huge amounts of facts. And it is literally, so not only are lawyers trying to keep as much of that information freshly in their memories, but they're also having to deal with the procedural ins and outs, the intricacies of the procedures. And it is a lot to keep track of. So it wouldn't surprise me at all for Rashbaum to say, I had a signed waiver. He remembers that a written waiver was prepared, and he delegated it to somebody else to get Charlie to sign it, and it never got signed before Charlie got moved to North Dakota. And I mean, all of those things are entirely possible for it to really be, an honest mistake. So I wouldn't jump too quickly to that conclusion. These cases are so data rich. I mean, there is so much information that it is literally impossible to keep it all in a human brain. I mean, we're talking about, in the Vallow case, several terabytes of information, and I know that in this case, in the this case as well, hours and hours and hours of jail calls and surveillance calls and the bump, and there's so much for them to keep in their heads. And no matter uh, how many staff members you have, the knowledge of the case is sort of delegated out satellite style to those people as well. So I don't think that I doubt that it was particularly purposeful on his part. Um, and Becky says Joel just replayed the interview on tonight's episode, and Dan did say that he had signed waivers from all four of the Adelsons. He may very well have thought he did. It's one thing to have a document in your file. It's another to leaf through it and go, oh, I don't have a signed copy. For anybody that's ever dealt with a legal file, so you might prepare a document. Let's say it's a plea agreement, or it's a document that needs the court to be signed. So what happens is the original gets filed with the court, and what you have in your file is a copy. And it's what they call a conformed copy. So your conformed copy just has a note on it that says it was signed in this date, but it doesn't actually have a copy of the judge's signature because the original's in the court file. A lot of times those things happen, not necessarily, not just things that have to be signed by judges. So it's very possible that Dan Rashbaum leafed through the file and said, "Oh, I've got a copy of that waiver," and didn't really realize that Charlie hadn't signed it. So, I mean, I think that it is very possible that it was an honest oversight on his part, because, to be honest, it's kind of a no harm, no foul situation. Because even if he had a a, a, um, a signed waiver, I noticed I had a little glitch, and so uh, let me know if things are not, if you're not hearing me or things aren't good, because I'm on somebody else's Wi-Fi tonight. Even if he'd had a completely executed and signed waiver from all four parties, at any point, Charlie could have said, I've changed my mind, because waivers are one of those things that in the law we say are ambulatory. That means that they can be changed. So wills, for example, are another thing. It always gave me I always got a kick out of that, because my wills and trust professor was this very sweet man who, when I was in law school in 1989 or 90, was 80 years old. And the the law school I was at, the classrooms were sort of on one side of the campus, and the staff offices, the professors' offices, were on the other side, and in between was the cafeteria and the sort of student lounge. And so we had wills and trusts right after lunch. So we'd all be sitting around having lunch, and we would see Professor Belsheim, who was he was a great teacher, but he was 80 plus. And he would start walking to the classroom. We all knew we had time for another cup of coffee while Professor Belsheim was very slowly making his way to the class. And one of the very first things he taught us was that wills are ambulatory, meaning that they can be changed at any given time. And we all joked, well, wills may be ambulatory, but it's a little questionable about Professor Belsheim. So that's how I always remembered wills are ambulatory. Well, waivers are ambulatory too, meaning that they can be changed. So, I mean, even if Dan Rashbaum had 4 fully executed waivers, Charlie could have, on the day of opening statements, after the jury had already been selected, say, no, I'm withdrawing my waiver. So, it's not ideal, but I think that is the reason why Judge Everett begrudgingly but understandably said, we don't have any other choice but to set this over. It's not as if, even if it had been anticipated, it could have, the same result would have happened, even if they'd had signed waivers. Yeah, I don't think it makes Dan Rashbaum look great that he didn't get the waiver signed, but I think it's unfortunate. Mary says, "Can you imagine the jail calls between Donna and Harvey last night?" Oh yeah, I can imagine those. Yeah, and worse yet, she wasn't able to call Charlie and give him holy hell for it. Um, so. Why don't we see if anybody's got last questions? I'm Jen. I'm going to take yours, and my Jen can see if there are any last questions. So Jen Chapman said, "I believe Wendy may not have been aware of the plot until after it was planned, and telling her boyfriend was a cry for help?" Question mark. I get she is liable, but what about the boyfriend? He didn't report it either. Well, maybe. I think that, first of all, I'm not really sure um, when Wendy told him that. Um, it, significant others tell someone something, and that person has to decide how much of it they believe. And he and Wendy were going through, I think, a rocky sort of the ending of their relationship. And that colors how you look at whether that person is telling the truth or not. He was very clear that he felt that Wendy was seeing other people and she wasn't being honest about it. Um, she was not really being forthright about that, and he felt that she needed to be. They'd been in a relationship for a while, and she felt like he owed her at least the honesty of letting him know if she was seeing other people. So, I mean, I think he had some reasons not to really find what she was saying trustworthy. And that is a pretty outrageous kind of an allegation. If somebody says to you, I think my brother was involved in killing my ex, I don't, you could sort of excuse Jeff for saying, oh, no, how much of this I believe, or how much of it you're just trying to scare me off and get rid of me. So, I mean, I could see how it would be a little hard to wrap your brain around that. I think that Wendy knew on the day that Dan Markel was killed, because she drove down that street. There are two reasons I think Wendy knew about that. First of all, she drove down the street and saw the police cars. And she, she gives us tortured reason why she was driving down that street. But sometimes I just drove down because it made me, because I was sad. And that's all BS. Wendy was never sad about her ending her marriage with Dan Markel. So the other thing that I think is so telling, and really doesn't come up in the conversations in the examination of Wendy, and I really wish Georgia would point it out. When the police track Wendy down in a restaurant, and I've always been kind of interested, how did they know where she was having lunch? But when they track her down in a restaurant having lunch with a friend, they tell her Dan Markel has been shot. She does not. Now, Dan Markel had their children, and he was supposed to drop them off at daycare before he went to the gym. It was his week to have the children. What mother who hears that their ex, who has physical custody of their joint children, what mother, the first question out of their mouth would be what? Oh my God, where are my children? Are my children okay? I cannot talk to you right now. I need to call the kids' daycare. Wendy does none of that. She never asks about her kids. That has always bugged the heck out of me. And if I were representing Wendy, I would have said to her, that is your fatal flaw. Two things happened. First of all, you drove down that street in front of Dan Markel's house, saw the cop cars there. You were looking for the cop cars. And second, when you found out that Markel had been shot and was being rushed to the hospital in very likely not going to survive, your first question was, where are my children? Are my kids okay? Where are they? I can't talk to you right now. I need to call daycare. None of that. So she clearly knew her kids were okay. That's my take on it. So whether or not she knew beforehand about the conspiracy, on the day that Dan Markel was shot, she knew. That's what I think. So I am going to, good question, Great Laker. Will there be a book club discussion after we all read the book? Can't wait. Mine's pre-ordered. Yes, I would love to have a book club. You all let me know in the comments below what format you would like that to take. Would you like to do it all in one session? Would you like to do more than one session? Where we kind of get together and talk about certain portions of the book. You all let me know what you think that should look like, because I would love to do that. And I would love to hear your feedback. I say in the acknowledgments, writing a book is both a solitary endeavor that takes a village. So on one hand, you lock yourself in a room and you write, but on the other hand, you really need the input of all the people around you. So I would love to do that. You all let me know what you would like. Also, if you would like, and this is for my YouTube followers as well as those who may have gotten the early digital copy, if you would like a signed book plate, please email me. Don't drop it in the comments. You don't need to make your address public to the world. But if you are willing to send me an address that I will not share with a soul, I will send you a signed book plate, personalized. So please let me know if you want to do that. There's no charge for that. That is just my way of saying thanks for being a listener and for pre-ordering the book. So do I think Wendy will be charged? I think right now, pre-Donna's trial, it's maybe 50-50. I think that if Georgia Kappelman had had what she thought was a winnable case against Wendy, she would have already filed it. But I think she, on the other hand, I think they've been very methodical about the way that they have knocked down the players and in the order that made sense. And I think that she is hoping that there is information that comes out at Donna's trial that might very well be the last little piece that gets them to reasonable beyond a reasonable doubt. So we'll have to wait and see. I'd say 50-50 at this point. So everybody, I'm going to say goodnight. Thank you so much for joining me. Thank you for putting up with our little bit of casual technology. I appreciate you all so much. I will be back at my regular desk next week. Well, let me put it this way. I had planned to be back at my regular desk next week, but I am going to be in Portland Wednesday night because I have those interviews to do. So what I will say right now is next week is TBD. Could be that I could do another little remote show from Portland and give you a little bit of a sneak peek at interviews. I'm seeing some feedback from Ladybug Lady. Hello, Ladybug Lady, that she would like several sessions. So maybe what we will do is come up with maybe a little bit of maybe a syllabus, like maybe we're going to do 3 sessions and it's going to be this part, this part, this part. And here's some thought-provoking questions, and then we can do that. I would love to do that. So let me know your feedback, definitely in the comments or by email. And I will let you know as soon as I know whether we're going to be on next Wednesday. And I will definitely post all my my book signing dates. And I'm hoping to add book signing dates as we go along. I've also been talking with my agent, and he's very interested in what could be a new project. So stay tuned for that. I'm going to say goodnight, everybody. Have a great week, and we will talk next week. Good night.